I see a black screen here, Kevin, if you want to share the slide.
It's being annoying.
All right.
Go.
Yes, let's start.
All right. Welcome, everyone, to this webinar on a very, very current topic, and we'll get into just how current it is in a second. We're going to talk about the EU Digital Omnibus on AI. Since you sign up for this webinar, you've seen the EU is considering a more or less significant rewrite to its digital rulebook for AI, for data, and for other topics. And this could lead to significant confusion about timelines, about obligations, about what organizations really need to do if they're going to use AI, if they're going to deploy AI to customers, if they're going to use it internally. And in order to address this topic, we have brought together 3 experts to discuss and potentially also disagree, which is very interesting, on what the AI Omnibus is bringing to us. And so I'd like to introduce all 3 of them and give each of them the opportunity to introduce themselves. So Laura, you're an AI governance specialist. Please tell us about your background.
Yes, hello, Kevin, and thank you so much for having me. And hello, everyone. The reason I'm here today is because I was one of the negotiators of the EU AI Act in its initial form, let's say, until it was approved in 2024. And then I briefly went to Washington, D.C. for a while, working on transatlantic AI policy issues. And now I'm back to Brussels and following the AI Omnibus very closely.
Thank you, Laura. Our second expert is Peter Henze. Peter is a lawyer and a veteran of dealing with the topic of digital technology and the law. Peter, can you tell us a bit about yourself?
Thank you, Kevin, and thank you for calling me a veteran. So makes me feel old. Okay. Well, only very few words to say about me. I've been a lawyer for almost 20 years. That makes me feel old, right? I really liked the AI Act in its initial form that was presented in 2021. I didn't like the part about the generative AI and the whatever they called it, like general purpose, which is not general purpose. So what they made of it, but in the end, together with a good friend of mine, we wrote a book about the AI Act, and we're currently dealing with implementing it. And now witnessing the limbo of the Commission with the alleged competitiveness and all the new provisions and timeline shifts. And actually, I'm lost. So I'm really hoping for Laura to tell us what's going to happen next, and for Patrick to explain to me what is it that is going to happen next, like materially. So.
Thank you, Peter. And our third expert is Patrick Sullivan, who comes from the audit side. That is, organizations that want to comply to technical standards, that want to set up their governance and compliance. They contact Patrick to assess whether what they've built in terms of their governance is suitable for purpose. So Patrick, a few words about yourself.
Of course. And Kevin, I think I'd be remiss not to say, and I think the audience probably sees this at this point, but our community is so tightly woven. What you have here is not a panel of 4 experts, but a panel of 4 friends that legitimately get together. We coalesce to talk about these issues because they are issues facing not just us, but the globe. Everyone is dealing with and struggling with answering questions that we'll probably ask each other today. I serve in strategy and innovation at Align. To your point, Kevin, we're a cybersecurity compliance firm. My role is really one of education, ensuring that we as an organization are fully understanding to the best of our ability the global regulatory landscape and third-party compliance landscape so that we can educate executives, businesses, markets to make good decisions about how to protect the best interests of their organizations and those that they serve. So I'm excited to be here. Thank you, Kev.
Thank you, Patrick. And let's dive right into the topic. I prepared a slide here, but I'm not sure it makes too much sense to go deep into it and start right in where we are right now, which is in the hot phase of the negotiations about what's going to be coming out of Brussels and the changes that are going to come. And so I want to turn to you, Laura, as somebody who is following this closely and, of course, is involved in the process. Can you give our webinar attendees an overview of what is happening with the Omnibus, where we are right now, and tease us a little bit into the topic of the timeline, because that is now razor thin in terms of margins.
Yes, thank you, Kevin. That gives me a few minutes to make it as clear as possible. So first of all, we must distinguish the two parts of the Omnibus. As you have in the slide, you explained that there are two sides of this. There is the data, so-called Data Omnibus, that includes modifications to GDPR, Data Act, Data Governance Act, etc. And these are one package, one regulation, amending regulation. This follows its own timeline, and it's a longer timeline. What we are talking about today is the AI-specific Omnibus, which is amending the AI Act specifically, only the AI Act. And the issue of the timeline is of the utmost importance here, because we know that the bulk of requirements that apply to the high-risk systems, that is basically most of what the AI Act deals with, start applying from August the 2nd, 2026, so in a few months. So basically what this means is that the co-legislators, namely the Parliament on one side and the Council on the other, have just a mere few weeks to get their position straight compared to the initial Commission proposal. In particular, as we were saying, today is a very peculiar day because there will be the final shadow meeting, so-called, in the European Parliament, where the rapporteurs and their the representatives of the other political groups will come together and see whether they can come to an agreement of let's say, a package deal to be able to vote as soon as possible, because they are supposed to vote next week on March the 18th in committee vote in order to be able to follow the timeline. So in the meantime, the Council on its own end discussed just on Monday, so just a couple of days ago, the latest compromise version on the Commission proposal. And this Friday, they are supposed to approve at ambassadors level in Coreper the position. If these two, so Parliament shadow meeting today and the Friday Coreper goes well, we can stick to the timeline, which foresees that the Parliament will vote at the end of March to enter into trilogues, and the Council will do the same. In March and April, they will negotiate among each other, so Council and Parliament, in the so-called trilogues with the Commission to polish the final version. And then in a couple of procedural essential requirements of votes and stuff, May, June, the final votes to really set the position and have the whole procedure completed, to be able to go into the official journal in July and have the new regulation enter into force on the August the 1st, so just one day before the normal timeline would kick in. So if they make it, it's razor thin timeline. Otherwise, if they don't, what will happen is, like, even if there is a slight delay, if there is a disagreement, there are still many issues to sort out. So I'm not sure how they're gonna manage this. I think the complex issues are gonna be left to the trilogues, because that's when you have a bit more expertise, you know, 3 actors that together can come to with their legal services. So there's a bit more time to think issues through. If there is a delay, the Commission will propose, very likely, a split. What this means is they will propose a separate legislative proposal just to amend the timeline, just to postpone this August the 2nd deadline. And this can be negotiated really quickly because it's just one thing and everybody knows exactly where they're going. We know the Commission proposes December 2027 for Annex 3 systems and August the 2nd, 2028 for regulated products, so medical devices, lifts, toys, machinery, and so on and so forth. So everybody already agrees that this will be the final timeline. So I would suggest that companies start to think that this will be the future timeline, whatever happens, because whether or not this negotiation goes through, if it doesn't, the split will come and the postponement will be there. Sorry to be so long.
No, what could possibly go wrong?
Well,
Right.
Peter,
And
tell
at a
us
certain
right?
point,
what could go wrong.
well, and at a certain point, it's almost as if you have to believe the behavior. And Laura, I hate to ask you to guess, but do you foresee this coming to a split? Is that based on how we've performed in the past, how we'll perform in the future?
Mm. Well, I think that the most dangerous actor here is the Parliament. It's the most irrational actor by far. I've seen a lot of crazy amendments that go into every possible direction and reopen things that should not be reopened. But so I think now they are trimming through these crazy proposals and coming to, at least, I give you this major win, you give me this major win, left and
Did you
right.
say screening or screaming through these proposals? Both, probably.
I don't
I'm
remember.
kidding. I have to be, and sorry, I'm not the adult in the room at the moment, so I'm
Okay.
just worried about the effing timeline
Mhm.
and that, like, what am I going to tell our clients about the timeline? What do you have to do? What is it? What is like the worst possible outcome, depending on your
I
position?
think
What's
that
the worst outcome?
as I said, Peter, I understand there is a lot of confusion, and I'm also confused. Everybody's confused, even them, even them, especially them. Is that if they make it on time, then it's postponed by 1.5 years at the very least. So for Annex 3, and then Annex
And
1
they
even.
won't postpone again because it's about like security of like making your investments, budget allocations, and also 18 months. Still not that much given the current maturity of the existing systems. I mean, Patrick, you know what I mean, and Kevin, you can talk about what we both know. That's yeah.
And Kevin, to Peter's point, one of the things that I see as being a real struggle as we work with organizations to think through what building an appropriate management system, an appropriate way to operationalize responsibly developing and using AI, those organizations are kind of left in a lurch because we don't know necessarily when we think through our context, we're not necessarily absolutely sure. We don't have legal certainty about what our obligations really are. And so do we overbuild? Do we underbuild and hope that things change? There are just a lot of unknowns.
It was going to be my question for you, Patrick, because you deal in particular with organizations in the United States. They look at this from the outside.
They do.
They're maybe not even sure if the AI Act applies to them or not, or if this is something they should worry about. And at the same time, different US states are building out their laws. They're actually coming into force now much sooner than the AI Act. So what kind of questions do you get from them, and what do you tell them?
Well, and so uncertainty is ubiquitous today, I think would be the best thing to say. You know, you mentioned state legislation. We're even seeing indications that the federal regulation coming will push state regulation out of enforcement. So there are concerns on this side as well. You know, as I think about U.S. businesses' relationship to the AI Act, I mean, we're struggling to get over very basic hurdles. The definition of a high risk system, I think, is still in question for many U.S. businesses. And of course, because of the obligation, the burden that goes along with that designation, organizations here are a little bit reluctant to say, yes, we do have high risk systems that we're placing on the market. So that's step one. Step two is once that acknowledgement is made, as I said a moment ago, really understanding what we're building against and what our obligations actually are. You know, one of the things about the August 2nd timeline, though it does feel urgent now, we've had a little bit of time to get here, but it's a definite line in the sand. And I think organizations need a definite line in the sand. People need a definite deadline so that we can enact the change that we need to enact. By kicking the can down the road, essentially we open this back up again for people to pull back and not focus on what's most important. And for me, that really is the biggest issue.
One question. Article 111. Beautiful number. Shifting the timeline would also mean that the grandfather clause would shift the date. Do you know that?
No, tell me more, Peter.
No, it's really about like whether you're exempt for another certain period of time if your system had already been placed on the market before August 2nd, 2026. But this is like not necessarily, it's not a dynamic recourse to the application of the high risk requirements in section 2. So would they change that too, or would they leave it at 26? Because that's also an important issue for
Mhm.
a couple of things. I mean,
Yeah, there are some amendments in this sense. I haven't read the latest compromise on this, but
yeah,
they are figuring this out. I think they should be
it's
aligned.
yeah, it's a very like from a financial perspective, it's a very important question because a couple of companies I know they had been planning to roll out like on August 1st their latest product and then hope for the future. And now they may have to postpone or whatever do with these internal development get deadlines.
But also, why would they postpone? Like, if they put it on the market now, like August the 1st, they are still good to go. The grandfathering clause still applies to them. I mean, they don't have to
It would
comply.
still apply to them if they move the grandfathering clause up until 2027. They would have an additional amount of time.
Yeah, but so if they place it on the market now, they are good to go. Nobody's ever.
It's the life cycle issue. So in a year from
Yeah,
now, they have new features, and
yeah,
they're
yeah.
looking to. It's a trick to deal with the high risk requirements. I didn't want to go deeper into that topic, but it's like an important issue. They wanted to that was a loophole. 111 is a loophole, so that buys you some time because you can say, well, we placed it on the market before the deadline, and we can live with that for another 2 years before the next innovation cycle kicks in.
Yes, but Peter, you know that this is there because you cannot make this regulation retroactive, legally speaking. You're the lawyer, so you know more than me
Yeah, but
what
like
a
it's
mess it
some.
would have been. So
I know, but like from a practical perspective, it's a loophole. So we would have loved to have a very strict deadline that says, well, from this day on, you have to be compliant. While for the last 3 years, we've been running around telling people about different timelines, classifications. Like nobody knows anything. There is no legal certainty. The digital omnibus on AI is a horrible thing. It creates more uncertainty. It hinders innovation. It hinders R&D a lot because now nobody knows what they have to do. We
And
can't even sell them 42001 certifications. We can't even tell them, well, do that in order to be prepared in 2 years, because it's not even sure that in 2 years there's going to be an AI Act anymore. And that's like what really sucks.
And Peter, you
and
bring up a really, really important point. And I'm sorry, Kevin, you were going to say something?
I just want to make sure that our audience, if you're following us on LinkedIn, you can also send us your question, because as confused as we are here, if you're confused, feel free to send us your questions for our panelists, and we'll do our best to answer them. But as you can see, it's pretty tough.
But Peter, you bring up an incredible point of legal certainty and unknowns. We know that timelines are critical. You mentioned 42001, and those of you that follow my work know that I'm a fanboy of 42001 for what it's worth. Yeah, thank you, Laura. Thank you. That's actually how Laura and I met. Um, but nonetheless, for executives listening, though there is this uncertainty and though there are unknowns and though we are asking you to make an investment, the investment that I would ask you to make personally is building a management system, a way of thinking about developing and using AI responsibly in your organization that can be extended to meet future needs. That is the purpose of ISO 42001. You've likely seen a lot of half-baked arguments about 42001 not equaling conformity to the AI Act regulation. That's absolutely correct, particularly when we get into high-risk systems. I will also die on the hill of, though it does not provide a mechanism for presumption of conformity, 42001 provides a baseline, a framework from which you can extend to meet your obligations and your requirements. And so don't stop. That really is the biggest mistake you can make. We're talking about kicking these enforcement deadlines out. Laura, you said to August of 2028. For those of you that are starting now, that is just enough time to build a real AI management system that can accommodate the growth and change that you'll need for it to accommodate as more regulation comes online. That's a critical point for me, and one that I don't want our audience to miss.
A very important argument is you can find people out there who can help you with implementing the 42 series. You will find very few people out there can help you with implementing Article 17 standardization, because
Yes.
there is none yet. And
None.
you still have 20 months to go, which is basically nothing. So 4201, great starting point for everything. Should have been the starting point from the first
But
place.
wait, Peter, there is actually Adam Leon-Smith leads the work in Sensenelec on the quality management system, and they are almost there. These are yeah, they have gone to public inquiry until the end of the year. Now they are sorting out the comments.
Okay, now I am being a client here. Like, show me the numbers, show me the paper. Is it signed, sealed, and delivered? Like, is this a harmonized standard that I can rely on? Or is it a draft that you can purchase for 200 euros, a draft that has not even like been accepted by the commission at the moment? So, and that's the limbo we're talking about. It's super difficult. And the requirements under Article 17, I'm a big fan of 17 and also of 9, which is even closer to the 4201. But like at the moment, there is nothing that we can show and tell our clients that's what you have to do. Those are the people that you have to hire. This is the budget that you have to allocate for making your systems compliant. And that like really sucks. Instead, we are debating again about like 4,700 amendments or to an existing law from 2021 dealing with general purpose AI, which is already an outdated term. It's like really
Peter,
difficult to compare. I know I don't have to convince you. I just have to
no.
explain
I
the
agree with you that this
calamities.
whole omnibus creates more confusion than it solves, of course, by far. The amendments are 450 this time, not 4,000 like we
Yeah,
had to
well,
face. I
400.
had to
Well,
go through
that's
4,400, so I know what it's like. Thank you very much. But
screening and
what is
screaming.
yes, what two things. First of all, these two standards, risk management system and quality management system, are likely to follow more or less a reasonable timeline. They should be ready by, at the very latest, by the end of 2026. So if you have to comply by December 2027, you have 1 full year.
That's nothing.
I know
Laura,
that's
There's
that
nothing.
a
is
Okay.
Especially
there's a
when
problem, and this goes into a question we just received via
sorry.
LinkedIn, which
Mm.
is in this uncertain environment, how do you budget if the goalposts keep shifting? If your client asks you, how do I navigate this? How do I budget? Like, when do I do what? Given all the uncertainty we've now heard about, what do you do, Patrick? If one of your client comes to you, what do you say?
I say start with first principles. So again, the dead horse. Let's implement 42001. 42001 gives us a baseline, a management system from which we can build. Well, one of the things that's often missed, and Peter, you've been a really, really strong voice, an advocate for helping people understand this. But as we think about high risk systems, that Article 17 requirement applies to each high risk system. And so we have to think cleanly about not just our overall responsible development and use program. We have to think specifically around how we control each high risk system that we intend to place on the market. That's a lot. And that's a lot to do without a baseline to build from. So for me, let's start with 42001 and let's think cleanly about how we operationalize things like documenting use cases, documenting people, process, technology, how we think about risk of our use cases, how we think about potential harms that could befall stakeholders of these systems that we deploy to the market. Let's get that stuff down. Let's get the general stuff down so that we can then focus on specifics if and when we know when these regulatory enforcement deadlines are actually going to happen. I mean, that is my coaching. I think that's probably the best path forward to keep people from seizing and freezing on this idea that it's just never going to come. Because quite frankly, as I deal with businesses today, there is a bit of an eye roll. You know, we've kicked this can down the road so long. Is it ever really going to happen? Is this something that I really even need to take action on? The answer is yes. And let's do so in such a way that we create, again, from first principles so that we can get into the specifics if and when the time is appropriate.
So
Costs can be
to
all over the place to directly answer the question.
well, and to answer the question in a more pointed way, saying, well, this is also uncertain. I don't know what's happening. They keep changing their mind. Nothing is ready. Can I afford as an organization to just kick the can down the road and say, I'll worry about this in 27?
No, absolutely not. Yeah,
It's
that is
crazy. It's crazy. I mean, the same uncertainty that we see from a legal perspective, and we think, oh God, this is like abominable, and like the EU should like get their things together and present us with a great solution in the end. The same uncertainty is extremely appealing to investors on the technical side of this
risk.
problem.
It's
It's
risk,
like
people.
they all like,
Yeah,
let us embrace AI at every step of the value chain, but they are not embracing governance, which is like not very smart. I mean, I had a classical training in school with Aristoteles. Phronesis, like um, judgment, like informed judgment. So what we currently see is that like not so much practical wisdom applied to these situations, but basically like chasing rabbits. And that's like, it's like really, really crazy. And like, you need someone with practical experience in this field to help you create the infrastructure on which you can build your multinational, international compliance systems.
yeah,
You have got the software, you've developed it, Modulos. You, Patrick, you have the knowledge to like fill in all the gaps and create the stuff that is relevant for the crosswalks between the different standards and requirements. And Laura has the very specific knowledge of how you should interpret the law, like not just in your favor, but like how it is objectively interpreted. So, well, first step would be actually listen to webinars like this. Second step would be like start anywhere. Start with training. Like, what do I do to lose 15 pounds because like of COVID, whatever? Like people started running or someone else did something else. Like start for the first time. Like start with something. The same way they force AI tools on every one of us, on every employee, they could also force compliance tools on everyone.
Mhm.
I
I mean,
see.
what you mentioned something very interesting, which is these crosswalks between ISO standards, between the AI Act in its raw form and with the half-finished technical standards, and then you have NIST, and then you have various U.S. state laws, and then you
had NIST. Sorry.
You had NIST.
Sorry.
Casey.
Casey. You have a law in Vietnam. You have laws coming out in Taiwan. So if you're an international company, I mean, I fully support the idea of just do the crosswalks and start, because in the end, most of these things just ask you to do things you should be doing anyway when you're developing an AI application. Like, know where your data comes from. Have you analyzed it? Have you thought about if the distributions make sense? These things that should be part of your development process anyway, and you should have documented them. And how you precisely map that to article whatever of some law, that is a second step. And it sort of goes along with what you said, is like have a management system that you can extend, because there's a conversation I run into a lot, and it sort of mirror images. It sort of with a European company, they say, yeah, we need to worry about the AI Act. And I say, do you have customers in the US? Do you have customers in Texas? I have no idea, maybe. So are you aware that the law in Texas is already effective long before the act? No, I've never heard of it. And no, actually, they're not too interested into looking into it. And you get the inverse from a lot of American organizations that say, yeah, I'm really worried about certain requirements in the
California.
US, but the
Right.
AI Act, come on, it doesn't apply to us. We're American, like, right? I even had a tech executive who advised startups in Berlin, an American tech executive who advised startups in Berlin, advised German startups to incorporate in the US so they weren't subject to the AI Act. And I can see your reaction, Peter. But first, Laura, you have a point.
I have several points because I've been following and I wanted to react to many of the latest interventions. First of all, I would tell organizations, why don't you also participate in standardization activities
Yes.
to set
Yes.
them out yourself? If you want to contribute, actually your expertise is really needed right now. Instead of just waiting for something to pop on your head and that you have to implement, just get your hands dirty and work with Patrick and with
Please.
Adam in JTC 21 and the others to make sure that we get the standards right and incorporate your concerns, your company's concerns. I think there is a real possibility for industry there. The AI Act is not just a top-down type of regulation. The standards allow for industry to really dig in and set what the state of the art is for AI governance. And also, the unfortunate thing about this omnibus situation is the fact that now the Commission is wasting so much time on creating more confusion, because industry itself actually wanted this. The line being, oh no, this is too complicated, let's simplify it. Okay, then a lot of resources to simplify it, while the Commission was supposed to actually do something else, which was publishing the guidelines as to how to apply the high-risk regime, how to consider the high-risk classification, which would have helped immensely companies. And they have the Commission has missed the February the 2nd deadline, and these guidelines still don't exist. And so we are putting all our resources into something that creates more confusion than anything. But anyway, I would really like to conclude with saying by saying to companies, please participate in standardization activities in Sense and Elect. This is crucial.
Or in the
You
U.S.
know,
insights. And really quickly, Kevin, but before you take over, Laura, to follow up on what you just said, I think it's really easy for us to take this hyper focus on the requirements or the lack of understanding of the requirements of the AI Act today. The thing that listeners need to remember is that this is just the elephant in the room right now. 10 years ago, it was GDPR. 10 years from now, it will be something else. And so that's why it is so critically important that you build good internal structure that can accommodate change. That really is where the ISO standards, in this case, particularly 42001, shine. Kevin talked about this process of really understanding cross-contextually the various regulatory regimes that organizations are dealing with. And that really is one of the first steps of working through the process of building your context. So start with a known good standard, which is, in this case, most any ISO management system. For us, it's the AI management system in 42001. Sorry, Kevin.
um, John from the audience had a question for Peter about your point about 42001 and the deadlines, and he's asking if you can go into a bit more detail about your concerns about 42001.
I may have already answered that like on LinkedIn because I thought it was just a misunderstanding. I am fully in favor of using standards and familiarizing yourself as a company with the standardization landscape, because it's not just one standard. We're talking currently about existing more than 55 different standards in this field from various organizations of medical devices. We even have a new one from February 2026, and it's even a European norm. It's a European standard on a guidance for drafting normative documents suitable for the use for conformity assessment. So people don't know that there is even a standard for the conformity assessment documentation if they don't know that. And that leads me to the point where I say, well, Laura, yes, of course, people should participate in standardization, but this is a growing a field where people are adapting this technology, whether good or bad, at a rapid pace, and people who have like no idea of what is behind that technology. So you can't have them participate in these things. No,
Okay,
never.
but then if
That's
you are
not a good,
an
that's
AI,
not a good idea.
no, I'm
But
talking about companies who are AI providers.
they
So if they
are,
don't know how to deal with it,
but okay, so these providers, you can become a provider out of your own bedroom by deploying some stupid stuff to this world. That's the new situation that we're in. So also, I don't want these people to contribute. And currently, I don't want them to contribute to standardization. I'm really sorry. I really want experts there. The problem is, as you know, we have smaller countries and they have like one expert for 17 different standards, but they only have one day available. So that's why they outsourced everything to PwC and stuff like that. Like we know these problems, but like I would say before participating, start reading. Start reading standards and then figure out like, well, they might give you an answer the law can't give you. Like chapter 2 and 3 AI Act, like you understand them much better if you read all the ISO IEC and the European norm, the Sensenelec stuff before that, because otherwise the law is completely not understandable, can't be understood. I'm just saying.
Peter, one counter to that I've experienced myself, they say documentation doesn't create process. You have to understand the process and then document it. But what I found in actually participating in these expert groups is that there's this whole standards infrastructure that's largely administrative. The comments, the feedback are largely editorial. I will say there is significant value in real technical experts offering opinion about how things really work as opposed to just how they should work. It's that consensus in opinion about implementation, operation, again, how things actually work in the field. that for me is so critically important, because we've seen standards that just don't fly when you subject them to real testing. I think for us to continue moving forward in such a way that the world actually trusts international standards, these things have to be fit for not just purpose, but also use.
I want to make one more final call to questions from our participants, and I want to move a little bit away from the deadline discussion and the standards discussion to the other changes in the AI Act and the AI Omnibus that they're being contemplated. And of course, we don't know what ultimately will be decided, but Laura, can you give us a sort of a brief summary of what other changes might be coming?
What other changes compared to what? Sorry.
To the original AI Act.
Okay, wow. So, changes. The AI literacy obligation will not be an obligation anymore, very likely. It will, I would maybe suggest to follow more closely the proposals by the Council, which are much more reasonable than the ones proposed by the Parliament so far. They will just, they propose to apply AI literacy obligations only to providers and deployers of high-risk AI systems, only for the respective articles that they have to comply with. I think it's 17 and 26. And Article 6, the registration obligation for non-high-risk AI systems will still be there. It will be reinstated, even though the Commission wanted to delete it, very likely, at least. This is what I get, because there is no majority to delete it so far. It will just be streamlined, simplified. There are changes on SME provisions will also be extended to small mid-cap companies. So a little bit more leeway in Europe. We cover basically virtually almost all companies by extending this to small mid caps that will have then not an exemption, but reduced certification fees, dedicated access to compliance tools, and so on and so forth, priority access to sandboxes, etc., etc. There are some measures on the one important thing is the possibility to train AI systems using sensitive personal data. This is in tandem with the GDPR the data omnibus, so the GDPR modifications that will follow a different timeline. So let's see how that plays out. But in the meantime, the AI Act is shaping up to open the possibility to use sensitive personal data to detect and correct bias for AI systems, not only to high-risk AI systems, but to all AI systems. Please don't laugh. Please don't laugh.
No,
I've been
it's like
suffering
it's like
enough.
the mostest stupidest idea
I know.
ever.
Maybe
What
if
they
I
have,
may,
like
at least,
oh sorry.
Oh,
yeah, I'm concerned as well, especially about opening it to every possible AI provider. You know what? Why? Because
wow.
these providers do not have any data governance obligation. So, whatever, we just process sensitive personal data like that,
And
And
they can't even put it in silos. They are
yeah,
unable
exactly.
to differentiate the different categories of data because
Exactly.
anyway, it's a mess.
And But I think there is a proposal coming up, maybe from the Parliament, that I hope it flies. That is a notification to the Data Protection Authority in case you do this. I don't know exactly how they are phrasing it, but we will know very soon. In any case, it is concerning. Unfortunately, the GDPR modifications also go pretty much in that direction. They narrow the definition of personal data. They open to the training of AI systems as a legitimate interest to to process personal data. So, I mean, we have a number of setbacks from the original data protection regime that we had in Europe, and the AI Act is just adding one allegedly small bit compared to what is happening with the GDPR, and we will see about that soon. And then,
Folks,
of course, there are measures about enforcement, the timeline we already discussed. This is basically most of
folks,
it.
we're 45 minutes in. It's been a really good discussion. I want to sort of move us towards the end and give each of you 2-3 minutes to summarize your thoughts, your take on what organizations, what IT, what AI leaders should be doing right now. How should they navigate the situation? We titled the webinar as being anchored on what should organizations do. So what's your practical advice to them? Maybe Patrick, do you want to start?
Sure. And I think it's simple, Kevin. I think it's don't wait. You know, I think in light of unknown, in light of ambiguity, in light of what appears to be chaos, that the natural tendency is to freeze, to wait for things to change so we can make a good decision about next steps. I'll tell every organization listening that that really is not a viable option. It's too high risk. So immediate next step, purchase a copy of ISO 42001. At least you'll have it. As an organization, if you decide that it's not the right framework for you, at least you've reviewed it. If, however, you do recognize that the value, the utility of the framework, with that standard, begin evaluating your use cases and documenting them and getting some sense of the real risk you're imparting on the ecosystem by deploying tools to the market, whether it's the EU or any other market. But start today. Do not wait. Don't rest on your laurels because it really is a fool's errand to hope that at some point when clear determination is made that you'll be ready to implement the tools and the frameworks and the systems that you need. It's far too large a task. So I said it was a few words. I lied. Don't wait. Take action. That action really is fairly clear what needs to be done next.
Laura, what would you advise?
I agree pretty much with Patrick. I would add, okay, don't wait, but also don't panic. Don't panic over every possible amendment you hear about, because you only need to care about the final version of this omnibus. In the meantime, start planning as you would with the old version, because basically the requirements will still be there. The articles that form the core of the high risk regime are not changing. So from 8 to 15 and then 17 for the quality management system, they are not changing. So you can really start from there and from the very beginning of your AI system development.
Peter, I give you the final word. What should organizations do?
Not get distracted, not by the war in the Middle East, not by other missed targets, weakened positions, or collateral damage. Most importantly, GDPR will survive. And if you don't think you have to start with AI compliance, then you should think about becoming compliant with Article 22, which has received a completely different form and shape by recent judgments of the CJEU, especially, for instance, that Article 14 of the AI Act is now has become an integral part of 22.3 of GDPR. So everything has to be manageable, has to be monitored and controlled. High-risk systems under the AI Act are also considered high-risk processing under GDPR. So even if they tweak GDPR a little bit, and even if they postpone the AI Act, you can't escape good governance. It's impossible.
Yes.
And you better start now.
Laura, Patrick, Peter, thank you so much for joining us today. And to our audience also, thank you for joining. I hope you found this useful. And we will be sure to organize more webinars like this that help you navigate these really, what do you say, interesting times. So thank you very much.